Dear friends, here is a new spotlight on matrimonial cases. Of late, that means recently, for the past few months, at least for 1 year, the judiciary is adapting a new approach in respect of matrimonial cases related to dowry harassment, domestic violence, maintenance issue, and transfer of application of a woman to the place of her choice under special cases. So this 490 for 304B of IPC and 125 provision under CRPC and some special provisions of for transfer of application matrimonial case. These are being very much misused by women or by petitioners, we can say. Because they are being misused, the judiciary has no other way out accepting adapting a new approach. Recently, the Delhi High Court Chief Justice Subhash Jaya attended one convention at Chandigarh during first week of March 2026. While delivering a speech, very interesting speech there, he said like this regarding his matrimonial cases. He said, "Law alone cannot do justice to matrimonial cases. Within the four walls or within the four corners of law, justice cannot be sought up to. We cannot search for justice within the four corners of the law because the issue, matrimonial issue, is a mere social problem than a legal problem. It is a social problem, but at the same time, it is related to legal. But legal issue is not the matter there, it is the social. What matters is, here is social issue that matters a lot. So for that, what we have to do is that we have to adapt a new approach, sociological, psychological, philosophical approach. That means interdisciplinary approach. Then only you can, by displaying or by the display of a true legal learning, exact legal learning, with the help of interdisciplinary approach, we can seek justice. This is what he said there at Chandigarh. Now we shall see some cases related to dowry, domestic violence, maintenance, and transfer of matrimonial cases, etc. Before that, before giving for each and every concept, I shall give two cases here, latest cases. Before that, I would like to make a reference to great philosopher, socialist, and legal thinker Dworkin and H.L.A. Hart also. What they said about the law, the provisions of law is this: law is not merely of rule; it deals not merely of rules. Law also includes non-rule standards, he said. How far we shall see now. So regarding this dowry harassment and domestic violence cases, I shall give you two cases here. Supreme Court recently in Dr. Sushil Kumar Parbe versus the State of Patna 2026 decided on 9th March 2026. In this case, a very interesting thing is quarreling between father-in-law and daughter-in-law. This quarrel has reached to its zenith, that's all. No horror, no violence, no untoward incident, nothing of that sort. They quarreled. And this daughter-in-law filed a petition in the court of, from district court to high court it has come, Patna High Court. And there it was not clear, and finally it has come to Supreme Court. There in the Supreme Court they said, what is this? Quarrel between father-in-law and daughter-in-law. Quarrel between mother-in-law and daughter-in-law. And daughter-in-law versus sister-in-law. So all these are family members. See, the quarrel between family among the family members is not an offense. It's not a crime. There's no any crime at all here. So it's a sheer misunderstanding, sheer emotion. By that sheer emotion, the daughter-in-law has filed a petition. So it is not considered. It's only an emotional approach that should be subsided. So the case has been completely this is a dowry harassment and um, domestic violence. These two concepts are not here traced out. No true evidences also are produced. On the basis of this, Honorable Supreme Court has dismissed the case. And the daughter-in-law's case, according to these two laws, section 341, 323, and 498A of IPC, and section 3 and 4 of Domestic Violence Act have been subsided. They are not at all proved in this case. So Supreme Court declared that it is null and void. The petition has no validity at all, declared. And in the second case, Dara Lakshmi in Telangana, Dara Lakshmi Narayana versus the state of Telangana. In this case also, the daughter-in-law filed a petition. She registered FIR. Investigation charge sheet is also issued. Investigation went on for a long time, and afterwards, finally, the judgment by Supreme Court. That means from High Court to Supreme Court it has come, and finally at Supreme Court they declared that it is not proved. It is nothing but just misunderstanding and personal vendetta. Because of that only, the petition was filed. So there are, and Supreme Court also commented like this in its obiter dicta. No, there are flow of cases, number of cases, countless cases related to these dowry harassment and domestic violence, but they are not proved finally either at High Court or at Supreme Court. This Dhara Lakshmi Narayana versus State of Telangana was settled down in also in February 2026 and related to maintenance as per Section 125 and some provisions in the Domestic Violence Act. How? Here maintenance, it is very interesting. This Hazari Court, Delhi, declared one case in an interesting fashion. The case is about Kiran Jyoti Manai versus Anish Pramod Patil, settled the civil case number 691 of 2022, settled in March 2024 by Tis Hazari Court. Here in this case, the wife filed a petition for maintenance. She wanted to be separated. She wanted to take divorce from husband. Okay, well and good. You can take divorce, no problem. But she applied for maintenance for her and for her child also. The background is she has been divorced from her first husband and she got a child also. She has begotten a child, a daughter, and from her first husband she got 40 lakh rupees as maintenance, a fixed maintenance. And the second one is she studied MBA HRM and other additional qualification also. And the third one is from the realization of mutual funds she got 50 lakh rupees. Third one. Fourth one is she has self-acquired properties also. Worth rupees lakhs of rupees. Totally crores of rupees she has got. Even then she applied for maintenance under this section 125 of CRPC 1973. What a wonder it is. And you can imagine very clearly that even in respect of the woman who has been running hand to mouth life, but she has education and father has job and father has some property. Even in such cases, maintenance is not being granted. So in this case, here in this current case, you can imagine that the government, the Supreme Court has bluntly rejected, denied. The maintenance is denied, but Supreme Court may be following a new approach. But if it is reasonable, so in reasonable cases, maintenance is being granted. For example, in respect of D versus N transfer application, transfer petition number decided on 27th February 26, 2026. In this case, the husband was directed to pay 25,000 rupees, whereas he could not pay because of some troubles in the meanwhile, interim trouble. Finally, the court ordered that he must definitely pay 25,000 rupees per month to the woman who has been divorced. So, in reasonable cases, maintenance is being granted. And when we come to transfer of matrimonial cases, very interesting cases, two cases I would like to make a reference here. One from Madhya Pradesh High Court, Ekta Vaish versus Deepak. Another one is Kerala High Court, X versus YT appeal number 420 42 yes 42 of 2026, decided on March 2nd, 2026. In both the cases, the wife appealed for transfer of cases to her own choice, to her native place. See, if it is 300, 400 kilometers distant from her native place, from her parental home, okay, it is reasonable. Even for 50 or 100 or 200, 150 kilometers, they are making demand. And that too at middle stage or some developed stage of the case. So in both the cases, they have not accepted. The Supreme Court has rejected the application request for transfer of matrimonial cases to her own choice. If it is reasonable, for example, in some cases where she has no other maintenance, she has no income sources, and father has no sufficient adequate income, in such cases, the court has directed that the husband must bear the expenditures also for her journey to the court. So, under some exceptional cases, reasonable cases, even her fare to attend the court is being paid by the husband. But in other cases, even the transfer applications, once upon a time, automatically, either at lower level or at the high court level, the transfers were being transferred very easily. But now it is not so. So, the lot of a new approach has come. No question of inconvenience, nothing doing. You have filed a petition and you're doing some problem, creating some problem to the husband, and at the same time you are also requesting for transfer of that matrimonial case to the place of your choice, place of your court, nearby court. No, it is not possible. The Supreme Court has declared. So what we have to know here is that Justice Chalameswar, former Justice Chalameswar, he made a wonderful remark in one context. He said that a great way, that is there is a great way of doing some small thing, and there is a small way of doing great things, he said. Here what I would like to say here is, in this context, with reference to this former Justice Chalameshwar, is this: see, great way of doing small things, see, this maintenance via transfer and domestic violence, false cases and all small things, but we are making it a great, we are following the great way, difficult way, magnified way of going to district court. These cases can be short cases. These cases have gone to high court and then Supreme Court. That means great way of doing a small things. In fact, we have to follow this small way of doing great things. Suppose you think that this is great, very difficult, complex. See, human relationship, it is nothing but lack of human relationship, lack of misunderstanding, lack of sweet affinity between wife and husband. That's a, it's a small thing. But we are making it a very difficult thing, a complex thing. Suppose you think that it is a complex issue, most difficult issue, a great thing. Okay, that's a small way of doing this great thing. That is sorting out the issues there itself in a district court, sessions court, a family court. Otherwise, ADR system. You just approach ADR system, or mediation. Enough. So these great things can be sorted out by small way, small way of doing great things. And that is why former Chief Justice of India, D.Y. Chandrachud, while delivering one speech in SGT University, he said like this: there are some types, two, three types of lawyers. One, they do everything, they means here liars. They do everything but law. But means without law, accepting law. They do everything. And some, they have the law, but nothing in the practice, nothing in the court, no argument in the court. So some people, the long and short of this matter is, some lawyers, they just stick on to the law, provisions of law, and no creativity. And some lawyers will have intelligence, good argument, but no law. The third type of lawyers, he said, is, see, there are a few lawyers, you can follow the law, the principles of law, and at the same time they will display judicious knowledge, intelligence, practical intelligence, and sort out the things very easily. So this is the issue, the new approach of the judiciary in respect of matrimonial cases. And what we have to learn is that what Chalameswar said and what this D.Y. Chandrachud, Chief Justice, said, exactly we have to follow that. If the lawyers follow it, they will not, there is no question of much said about nothing. I think it will be useful to you. Thank you very much for understanding. And if you are impressed, please subscribe and encourage me.